father with the child. It is important. In this case also for 2 years, the child was deprived of the father. The court says 1 month, the child should be shifted so that the bond can be created. This direction is rendered only for the reason that the respondent wife is not permitting visitation despite repeated orders and warranting shift of the custody from her shoulder. For a boy so young in years, these and other expressions suggesting a deep-rooted dislike for the father could arise only because of a constant hammering of negative feeling in him against his father. Which says that whatever be the background of the case, it cannot be so acrimonious so as to deny the right of the father to see his daughter. It basically says it's the basic human right of the child. And then courts have to be wary with the allegations because they paint them as villain. That's because it says a parent cannot be the guest in the life of the child. Thereafter, the court also recommends 31 to win over each other. Parents shall not use the child as a pawn against each other. The parents should not poison the mind of the child. These are the interesting point in this case is that the mother had at least 6 reported adulterous relationships and she was called a nymphomaniac. In the judgment of Vineet Gupta versus Mukta Agarwal, Delhi High Court, it has been held that even though the allegations are proved as regards the wife's extramarital affair, still, as far as the custody of the minor children are concerned, in a given case, same can be granted to the wife. In this case, it was a step further, even it's proved.
It is a humane problem and it is required to be solved with the human touch. A court, while dealing with the custody cases, is neither bound by statutes, nor by strict rules of evidence or procedure, nor by precedents.
A reply to reply.
Again, no, this is a very, because this is exactly on the same point by the same judge of the Supreme Court, which is why it's important. My lord, you may kindly share anything that can help on so-and-so number or so-and-so email ID as it may help me in safeguarding children's well-being. There is your own, this is what she's going to any extent. And when this is happening, when leadership had given the visitation rights, she knew that she's losing the grip on the children. I have to do something. She writes a message to Ketan. Give me something. I'm losing the case. Give me something. This is how vindictive she can get. And this kind of a person will let me see the children.
Yes.
She will not. Over her dead body, she will let me see the children. Thereafter, leadership will see the judgment which I pointed out.
Yes.
This judgment leadership is passed by the Karnataka High Court. We start with. Leadership, this was a case which I had occasion to argue. Para 15 of this judgment by Justice Nagpur. In this case, leadership, there were several orders of visitation which were repeatedly being flouted by the mother. And in para 15, the court says, a collage of the judgments of the apex court, as extracted herein above, the court has permitted shift of custody of the minor child to the other parent when the other parent has violated orders of court, but holds that in the best interest of the child, the court should pass appropriate orders in light of the aforementioned piquant situation and bear in mind the interest of the child as also the attitude of the wife in not adhering to the orders of the court. I deem it appropriate to give the following directions. First, the petitioner father shall be entitled to interim custody of the child for 1 month from the date of receipt of the copy of this order, which would be enough for bonhomie for the father with the child. It is important. In this case also for 2 years, the child was deprived of the father. The court says 1 month, the child should be shifted so that the bond can be created. This direction is rendered only for the reason that the respondent wife is not permitting visitation despite repeated orders and warranting shift of the custody from her shoulder. After 1 month, the concerned court before whom the proceedings are pending in GWC shall interact with the child and then pass appropriate orders. It is made clear that in the event the wife violates the orders passed by the court with regard to visitation, the court would be at liberty to pass appropriate orders in accordance with law, which could even be shifting of custody of the child to the hands of the father. The mother shall be solely responsible in the event court would be constrained to pass such an order. This is the order passed by the Karnataka High Court. Thereafter, this is the judgment which is a binding precedent on the importance of the role of a father. This is very, very appropriate and apt for the case. Leadership will see paragraph number 72. For the boys so young in years, it is basically what the court is deprecating the practice of the mother to be hammering negative things against the father to the mother. For a boy so young in years, these and other expressions suggesting a deep-rooted dislike for the father could arise only because of a constant hammering of negative feeling in him against his father. This approach and attitude on the part of the appellant or her parents, she lives with the parents' leadership, can hardly be appreciated. What the appellant ought to appreciate is that the feeding the minor with such dislike and despair for his father does not serve his interest or his growth as a normal child. It is important the minor has his father's care and guidance at this formative and impressionable stage of his life, nor can the role of the father in his upbringing and grooming to face the realities of life be undermined. It is in that view important for the child's healthy growth that we grant to the father visitation rights that will enable the two to stay in touch and share moments of joy, learning, and happiness with each other. So this was a case and they were living in different, but this is the finding of the court, Ruchi Majo. And these judgments were also relied upon in the other High Court case leadership. Thereafter leadership, this is one page judgment
Take that.
passed by the Supreme Court, which is very clear on the point, which says that whatever be the background of the case, it cannot be so acrimonious so as to deny the right of the father to see his daughter. It's basically that however bad a case can be, then leadership, this judgment which leadership has already seen in the impugned order, Rashita Sahu.
It's already extracted. in
It's
the
extracted.
snap
This
result.
is extracted. Yes.
It's a seen it. Which para of it?
Leadership in Yashita Sahu, paras 19, 20, and 21, 22. It basically says it's the basic human right of the child. And then courts have to be wary with the allegations because they paint them as villain. That is the finding of Yashita Sahu. Then leadership, this is another judgment which we relied upon in the trial court. This is on the point, which is this, I started with the judgment in the trial court. Because this judgment, the wife tried to say that the husband will sodomize my child.
Which para?
Leadership. Paragraph 6. Several police complaints were filed on this point. And despite that, the court said all this is negative and gave me joint custody of the child. I started with this because I knew all the allegations they will raise before. So I had already shown the judgment at the starting judgment. And it's relied upon, it's not, is reference in the impugned order. Para 6.
Or
Mr.
the-
Nagesh Reddy,
That those are all the complaints. And where is the order of the court?
leadership
Where
is,
is the ratio?
yes. The ratio of this case,
Para
leadership,
26.
para 26, because it says a parent cannot be the guest in the life of the child. It is if visitation rights only are granted for limited hours, it may not be sufficient for the child to have comfortable time with the father or mother, whoever the case may be. The wider the gap, the bonds get broken quicker, and the child is left confused and ends up believing this. Such acts of any parent in separating a child from the other parent should be nipped in the bud. Otherwise, the separated parent ends up becoming a guest in the life of the child. Overnight custody must be encouraged
Yes.
wherever possible. And mere meeting and spending time with the parent for a couple of hours in court premises, hotel, theater, mall, park, etc., under the supervision of the other parent or relative will not serve any purpose of visitation, as the child will be under psychological pressure and will not be comfortable. Thereafter, the court also recommends 31 to win over each other. Parents shall not use the child as a pawn against each other. The parents should not poison the mind of the child. These are the findings given in para 31 in this case. This is also relied upon by the trial court. Thereafter, leadership, there are 3 judgments on the point of adultery. They passed by the Bombay High Court and the Delhi High Court. It will have persuasive value, leadership. He is also relied on in the trial. There you have it. This ladyship, I again had the opportunity to argue this in the Supreme Court. The interesting point in this case is that the mother had at least 6 reported adulterous relationships, and she was called a nymphomaniac in the petition. And in this case, again, the court said this is all matter of trial. It cannot be decided here. And this was a case of a custody of an 8-year-old daughter. This particular case, then who became 9 years thereafter. But in this particular case, the court in paragraph 45, ladyship will see. The submission made on behalf of the petitioner husband as regards the adulterous behavior of the respondent wife, according to me, these are the allegations which are made in the marriage petition by the husband before family court filed in the year 2020. The said allegation has to be proved by leading evidence of the family court. Therefore, based on the allegations, the doubt as to whether the custody can be given to the wife will have no bearing. There is no doubt as held by the various judgments that not a good wife is not necessarily that she's not.
You're reading para number?
45, ladyship. 45. And then it relies on a Delhi High Court judgment, this judgment itself. In the present case, regards the allegations made by husband are still not yet to be proved. In the judgment of Vineet Gupta versus Mukta Agarwal, Delhi High Court, it has been held that even though the allegations are proved as regards the wife's extramarital affair, still, as far as the custody of the minor children are concerned, in a given case, same can be granted to the wife. In this case, it was a step further, even it's proved. So they are trying to paint their entire case on the point that they have already proved, when I am denying it again and again and again. They say, no, we've already proved it, and as such, we won't allow it. Similar judgment issue of Ratnamala. This was again part of the lower court record, in which the court again said in para 17.
Yes.
Para 17, leadership of the judgment, which the court deprecated the practice of trial court, which had proceeded on the basis without going through the evidence and saying that the mother was adulterous and denied visitation. That order was overturned. Another fact for which definitely objection will have to be taken in respect of the observation para 66 of the impugned judgment, which are in respect of allegation of adultery. It appears that the opponent had produced on record the transcription of the mobile conversation between the applicant and the said person, and the copies of their photos showing closeness along with his affidavit. That evidence has been considered by the learned trial judge without it was proved in all legal aspects. For the mobile conversation, it appears as is absolutely no discussion, there was no mandatory certificate of 65B. So also as regards the photos are concerned, it appears that the concerned photographer was not examined and these documents have not been separately exhibited. There was no opportunity of the wife to cross-examine the husband, and therefore though the fact of adultery is alleged and it has not been proved by cogent and conclusive evidence by the husband, the trial judge ought not to have considered it for a sentence also. Further, in paragraph number 68, the learned judge went on to observe that those allegations regarding relationship of the wife and the said person were not without foundation or reckless. That was a factor which has been taken by him for considering deciding the custody of the children. This is totally illegal. When the full-fledged evidence was not led, the court had not come to the conclusion that the allegations of adultery are proved merely because some documents have been produced.
Yes.
So this is the judgment. And the third, or Delhi High Court, which edition I've already pointed out, but I'll also give a copy.
Para number?
Para 27. The evidence on record reflects that the respondent mother frequently spent her time by taking leave from the office or otherwise with a third person, so-and-so, in whom she had special interest. While the overemphasis of the entire evidence has been to prove the extramarital affair, but there is not an iota of evidence to show that whatever may have been the personal affairs of the respondent mother, she in any way failed to take care of the needs of the children. The respondent mother may not have been a faithful or a good wife to the appellant husband, but that in itself is not sufficient to conclude that she is unfit to have the custody of the minor children, especially when no evidence has been brought on record to prove that she in any manner neglected to take care of the children or that her conduct has resulted in bad influence of any kind on children.
My lord, I have one more thing, one citation to place before the court.
Yeah.
That is that is AR 2024 Supreme Court 1299 at paragraph, the principles, paragraph 13.
Yes.
Correct. Left hand side.
Hmm.
In Neil Ratan Kundu and another versus Abhijit Kundu, this court laid down the principles governing custody of minor children and held that welfare of the children is to be seen and not the rights of the parties by observing as under principle governing. In our judgment, the law relating to custody of a child is a fairly settled, and it is this: in deciding a difficult and complex question as to custody of minor, a court of law should keep in mind relevant statutes and the rights flowing therefrom. But such cases cannot be decided solely by interpreting legal provisions. It is a humane problem and it is required to be solved with the human touch. A court, while dealing with the custody cases, is neither bound by statutes nor by strict rules of evidence or procedure nor by precedents. In selecting proper guardian of a minor, the paramount consideration should be the welfare and well-being of the child. In selecting a guardian, the court is exercising parents' patria jurisdiction and is expected, nay bound, to give due weight to a child's ordinary comfort, contentment, health, education, intellectual development, and favorable surroundings. But over and above physical comforts, both moral and ethical values cannot be ignored. They are equally, or we may say even more important, essential and indispensable considerations. If the minor is old enough to form an intelligent preference or judgment, the court must consider such preference as well, though the final decision should rest with the court as to what is conducive to the welfare of the minor. Pausing here for a minute, my lord, your lordship had that occasion to see both the children, how they behave and what was their expression. And the son also expressed that the conduct of the respondent, behavior of the respondent was not proper. That was expressed to the court at one instance. Now, we are unable to appreciate the approach of the courts below. This court in Katina of decisions has held that the controlling considerations governing the custody of children is the welfare of children and not the right of their parents. Kindly come to paragraph 15. This court in Roxanne Sharma versus Arun Sharma opined that child is not a chattel or ball, that it is bounced to and fro. Welfare of the child is the focal point. My lord, the welfare of the child is the focal point.
Yes.
Now, there is one judgment I want to point out in response to what he just said, because he showed a judgment of Justice.
No, a reply to reply.
No,
Again,
this is
reply
a
to
very,
reply will
because
not
this is
go on.
exactly on the same point by the same judge of the Supreme Court, which is why it's important.
My lord, if that is so, I have
This-
something more to read out
this
of
is a
it. I
judgment-
don't want to trouble the court at this.
Justice C.T. Ravi
Yes.
Kumar's judgment, when he says a 9-year-old child said that they want to be with a particular parent, and Justice C.T. Kumar said, no, I will not listen to you. I will decide what is in the best interest and I will
Agreed
not
with
listen
the
to you.
order.